Let's define administrative law. Some government actions that are seemingly unrelated to regulating private lives, in fact, do so. These include local building codes and zoning laws, school desegregation guidelines, equal employment opportunity requirements, minimum wage laws, and tax policies at all levels of government. The whole subject of government regulation in a free enterprise capitalist economy can be highly complicated and is always controversial. Some contend that the most effective regulator is the free market competition among those seeking to attract the buying public. They argue that government regulation, by interfering with the marketplace, works to the disadvantage of both customers and producers. Advocates of government regulation, however, see a greater need to monitor and guide the course of competition. They believe that a completely unrestrained market will inevitably lead to monopolistic practices, higher costs, underserved segments of society, and lower quality goods and services. Administrative law is an important body of U.S. law pertaining to the legal authority of public administrative entities to perform their duties and the limits necessary to control those agencies. Administrative law has been created by both judicial decisions and by statute. Historically, government regulatory activities have taken one of two forms. The first, putting certain limits on prices and practices of those who produce commercial goods and services, and promoting commerce through incentives, grants, or subsidies, on the theory that such payments are a public investment that will yield greater returns for the consuming public in one form of better goods or services. Making government regulatory policy has been regarded as a legislative power under the Constitution, yet Congress and most state and local legislatures have found it difficult to write all of the varied and detailed provisions that are a necessary part of governing a dynamic and complex society. The Justice Department is a cabinet-level executive agency responsible for the enforcement of federal law. At the local level, regulation of business activities most often involves granting licenses for operating taxis and establishments such as hotels, restaurants, and bars. Other kinds of local regulatory activities, however, can be very significant, such as housing and building codes, zoning ordinances, and interagency transportation planning. There's little research on local government regulatory impacts, which may be an unfair reflection of their scope and their importance. The social distinction between economic and social regulation merits further examination. The old-style economic regulation typically focused on markets, rates, and the obligation to serve. The new-style social regulation affects the conditions under which goods and services are produced and the physical characteristics of products that are manufactured. As early as the 1960s, the national government had significant economic regulatory responsibilities in just four areas: antitrust, financial institutions, transportation, and communications. While regulatory agencies might possess broad ranging discretionary authority to influence actions within a specific economic sector, their standards and guidelines generally did not affect the economy as a whole. Social regulatory initiatives were government actions in the late 1960s and early 1970s to regulate new social areas involving individual health, environmental protection, and public safety. These actions resulted in the creation of several regulatory bodies. Dealing with the problem of risk reduction, however, has not been easy. A fundamental difficulty has been how to determine the degree of risk involved in the use of, exposure to, a product or substance, and at what point a level of product risk becomes unacceptable as a general standard. Compounding the problem are high economic stakes involved in risk assessment and the little agreement that's been reached on risk criteria. A finding of a risk has come to carry with it real possibilities of a product being banned or otherwise restricted from the marketplace. Finally, with expert opinion looming even larger in disputes over just how much risk a given product or substance entails, the spectacle of dueling experts has become even more frequent. Numerous issues have emerged in connection with regulating products that many of us voluntarily use. The question of involuntary exposure to products, such as hazardous chemicals, secondhand smoke from tobacco, or toxic wastes, only compound this matter, especially the potential urgency for making new regulations and rules for risk reduction. Considerable tension has characterized the regulatory arena, most of it centering on the focus of regulating private economic activity. The extent of regulatory activity prompts us to ask what other factors account for its development. One way to explain it is a scenario of deliberate decisions by bureaucrats and their political allies to expand their sphere of influence over private sector activities. This explanation, often heard from conservatives to criticize regulations in which they oppose, is not a generally applicable explanation. Motives of compassion have led to rules and regulations aimed at protecting people from each other, governing relationships between buyers and sellers, employees and employers, and lenders and borrowers. The broader use of regulation also stems from efforts to increase public representativeness in government decision-making processes as one way to maintain a popular control and equitable treatment. Provisions of the Administrative Procedure Act of 1946 require procedural fairness in administrative agency operations, including detailed guidelines for public participation in many aspects of administrative decision-making. Regulation has been fostered by a willingness to have government protect individuals, groups, and society at large from many ills and evils. In virtually all cases, no intent to create red tape has existed, but it's inevitably accompanied with each effort. Past administrators streamlined many aspects of the national government's regulatory activity. Although a large part of its focus on regulatory restructuring was directed towards cutting internal agency regulations, past administrations have been concerned about regulations that affect private citizens and organizations. The National Performance Review signaled a clear intent to cut back unnecessary regulation in all aspects. Regulation was initially to be a function conducted by administrative boards and commissions with greater independence. That being the case, the structuring of those entities was a matter of some importance. As regulatory activities spread more widely through the executive branch, those activities did not alter the structure of existing entities. Questions of organizational structure are now less significant than they once were. The scope of regulation, the types of regulations issued and enforced, and the impacts of those regulations are often at least as great for other regulators as for older, independent regulatory boards and commissions. The combined effect of these provisions is, or was intended to be, that these entities were better insulated from political influence and manipulation than others in the executive branch. Decisions clearly favoring some interests over others are not uncommon, although most decisions have substantive legal as well as political roots. But where and how to draw the line between them is frequently decided through the political process rather than as a result of clearly defined boundaries. Regulatory structure seems not to matter on those occasions when either Congress or the President attempts to impose restraints on regulatory bodies that may have acted unacceptably or illegally. Different regulatory bodies are subject to the same sorts of constraints regardless of structure. In much the same way, the procedures followed by diverse entities have become increasingly uniform. Procedures used by regulatory bodies fall into two broad categories: rulemaking and adjudication procedures. A rule issued under this authority represents an agency statement of general applicability and future effect that concerns the rights of private parties and has the force and effect of the law. Adjudication is a quasi-judicial power delegated to agencies by Congress, under which agencies apply existing laws or rules to particular situations in a case-by-case decision-making setting. The rulemaking process calls for regulators to issue notices on proposed rules relevant to administration of any given statute within a period of public comment lasting at least 30 days. The Federal Register is a complete listing of all proposed and active federal regulations available online. Written comments can be submitted by interested parties, and if deemed appropriate, oral presentations can also be made. Although legislation can specify a deadline for publishing proposed rules and regulations, these deadlines are not always met. The Code of Federal Regulations is a record of all rules that authorize regulatory agency action. Regulatory politics is only rarely the partisan politics of Democrats and Republicans. Rather, it's the politics of privilege, in terms of those with a stake in regulatory policies gaining preferred access to decision makers. The political environment of regulation includes many of the same features that apply to all other administrative agencies. The President, Congress, and powerful economic interests frequently interact with a regulatory agency, therefore affecting what it does. Critics of regulatory agencies have charged that they often are more effective in protecting the industries that they're supposed to regulate than those that they're regulating them for. At the same time, however, another set of criticisms has begun to be heard, accusing some regulatory bodies of going too far in the exercise of their discretionary authority. Regulatory agencies are increasingly caught in a squeeze. Regulatory agencies operate in much of the same relationship to the president or governor than other agencies do. Political appointees head the overall organization, but career employees direct the work of the regulatory entity itself. From the standpoint of Congress as a whole, regulatory bodies have a great deal of independence. After an entity is established and the process of regulation is initiated, the main contact that members of Congress have collectively with this entity is in considering its annual appropriation. Congress does exercise considerable influence, however, through committee oversight of regulatory bodies, especially if complaints have been received about the activities of a given regulator. Among the most intense criticisms of the regulatory bodies has been the charge that they are owned, unduly influenced, or have co-opted by industries that they're supposed to regulate. The consumer movement has had a significant impact on government regulatory activity. Before the rise of consumerism, almost all major economic interest groups represented manufacturers or producers, those involved in the assembly, growing, processing, shipping, and selling of products in the marketplace. The regulatory function of public administration developed on a large scale beginning over 100 years ago. The doctrine of separation of powers seemed in this context to be something of a barrier to meeting contemporary needs. That doctrine, as in the past and the present, is designed not to promote efficiency, but rather to promote liberty. Although certain kinds of liberty are served by the separation of powers, speed and efficiency are not. It's precisely speed, efficiency, and reliability that are required for the governance in the 21st century. As the perceived need for greater governmental efficiency grew, the administrative apparatus of all government grew with it. As a result, the concern rose for establishing safeguards in the administrative system for the rights and liberties of those touched by the system. Administrative law pertains to the legal authority of public administrative agencies to perform their duties and also to the limits necessary to control those agencies. Administrative law is not clearly or nearly separated from other areas of the law. Rather, there's a distinct focus to this legal area that sets it apart conceptually from other areas. The principal focus of administrative law are the rules and regulations set out by administrative agencies and the law concerning the powers and procedures of those agencies across a whole host of operations. Procedural fairness ensures fairness in the adjudication process. Procedural due process is a legal term that refers to the legal rules governing a specific case. We will consider key provisions governing the general rulemaking process and significant guideposts in administrative law in this discussion. Rulemaking involves administrative issuance of statements and other guidelines that have general applicability. They set out to enforce standards that affect a category or classification of enterprises or activities. Rulemaking, especially if it occurs informally, is constrained by far fewer procedural restraints than is administrative adjudication, whether these restrictions arise from statutes or from judicial decisions. There are requirements that apply to rulemaking. Administrative entities are authorized to make three kinds of rules: substantive, procedural, and interpretive. Substantive rules apply to law or policy. For example, the Nuclear Regulatory Commission rules that set safety regulations for nuclear power plants, or FTC rules governing TV advertising directing at children. Procedural rules embody requirements for an agency's organization, procedures, or practices. They may be imposed by an Administrative Procedures Act, but may also be issued or perhaps supplemented by agencies. Interpretive rules are an agency's view of meanings of its regulations or statutes that it administers. Interpretive rules are analogous to an advisory opinion that might be issued by a regulatory or other entity. That is, they give some indication of how an administrator perceives or understands existing law. Occasionally, a dispute may arise over whether a particular rule is substantive, procedural, or interpretive. Such disputes are normally resolved by the courts, with both the government agency and the affected individuals bound by the results. When administrative agencies engage in adjudication, they act in a manner of a court. That means settling controversies among named parties and determining legal rights and obligations of the parties on the points in dispute. Courts have historically gone to greater lengths to ensure procedural fairness to individuals than to the public at large. This is one of the main reasons why administrative adjudication is the focus of so much administrative law. Adjudication may occur either formally or informally. Formal procedures entail three essential due process guarantees born in constitutional law and embodied in the Administrative Procedures Act of 1946. These are fair notice, an opportunity to be heard, and a decision rendered by an impartial decision maker. Other due process requirements that must usually be met include the individual's right to counsel, the right to present evidence, and the right to cross-examine. Informal adjudication, the more common of the two, may be conducted on a basis of mutual consent of the parties. Thus, it may take many forms and generally operates with looser constraints as noted earlier. A wide range of issues have been disputed and resolved by the courts regarding adjudication, especially the formal variety. In particular, the nature of a hearing itself is often at issue. Is a hearing required, and if so, at what point in the administrative action? What kind of hearing is required? What sorts of evidence can be presented? And how will the presiding officer, usually an administrative law judge known as an ALJ, evaluate the evidence presented, and how will he or she weigh the evidence in determining the outcome? The answers are central to procedural due process, which is at the heart of administrative adjudication in all its attendant rules. Factors that have contributed to increased discretion are legislative delegations of authority to administrative entities, professional expertise of administrators, and political support from organized groups. The central question pertaining to administrative discretion is how to balance administrative imperatives such as expertise, flexibility, and efficiency with judicial imperatives such as due process, equal protection, and substantive justice. Many conflicts manifested in administrative law have revolved around concerns that administrative arbitrativeness might result from the flexibility enjoyed by administrators acting in pursuit of efficiency. Consistent with this line of reasoning, those mindful of the judicial imperatives look to responsible administrators, executive and legislative oversight of bureaucracy, and judicial remedies. These are the safeguards of the life, liberty, and property of individuals affected by administrative action. Complicating regulatory reform is the wide variety of motives, assumptions, and policy objectives that have given rise to reform effort. More effective and more cost-effective regulation of the private sector is one potential goal. There are other goals, such as enhancing regulatory accountability to the president and increasing accountability to Congress as well. Yet another goal is ending existing fragmentation in substantive areas of regulatory responsibility. During the past 40 years, various reform proposals have been put forward that embodied one or more of these emphases. Finally, of course, there is a policy option of pursuing deregulation, the reducing of national government's overall regulatory presence. Predictably, strong movement towards deregulation opened up new issues concerning its impacts. It's impossible to generalize about the impacts simply because so many fields of economic activity have been affected by deregulation and, in some cases, in markedly different ways. Re-regulation is a decision by Congress or an administrative agency to strengthen or re-establish government regulatory requirements. Ongoing and ever more intense debates over government regulation have been inevitable in the recent years and in years ahead. Regulatory activity is strongly supported by some as a means of ensuring fairness and equity in the marketplace, while opposed by others on the ground that it poses a threat to individual economic and social freedoms. Regulation continues to be at a crossroads. Much more is at stake than a rule here or a regulation there. The nature of our economy and our government's relation to it are also.